This project is important because despite the inclusion of women in the legal profession and in the judiciary, we've not really seen any significant fundamental changes to the system itself. The law has stayed much the same, the legal system has stayed much the same, the parameters in which the law and the legal system works haven't really been rocked. So we're interested in the potential for the system to do better justice for women than it currently is, and I guess we were thinking that it's really incumbent on New Zealand judges and lawyers and academics and students to be more responsive to women, and particularly to Māori women, in the way in which they use the law. So the title of our edited collection is Feminist Judgments of Aotearoa, Te Rino, the Two-Stranded Rope. And the idea of Rino being the two-stranded rope is very important to both the methodology of our project and to the output. The two strands are the general feminist strand and then the mana wahine strand, and that is an independent whole within a whole. So the women working on the mana wahine, and actually one man working in the mana wahine strand, had autonomy to develop their ideas around mana wahine and to weave that into the project as a whole. So we're really excited about both the name and the way in which we've been able to achieve this. I mean, the first thing we did was to seek volunteers to participate and rewrite judgments that they were inspired to rewrite, and we let them propose what they'd like to do, and we then chose just about everyone who wanted to participate, which was fantastic. We ended up with 58 people. And we rewrote 25 judgments. So in a number of the judgments, there's different people working together. Each judgment has a commentator, somebody playing the role who actually just explains what's going on. So it's a little bit like a prolonged case note where they explain the case in its original context and the social and political and legal context for the decision, but they then go and explain what it is the feminist judge is doing differently. So that's quite a very important role, because the feminist judges are putting a judge's hat on, and they're writing judgments as if they were the judges. So sometimes the feminism is implicit, it's not that obvious. The commentator articulates what it is that the feminist judge is doing differently from the original decision. So in terms of what a feminist judge might do when they're rewriting their judgment, it can be very subtle. It should read like a judgment. It should be a credible judgment that could actually have been delivered at the time. So this is not a radical piece of work that could only happen in a law journal or in some other sort of fantasy world. This is a real life judgment that could actually have been delivered in our views. So they do things like draw feminist practical reasoning. That would be contextualising the judgment in terms of women's lives and the impact that it might have, instead of using abstract legal principles and trying to sort of stay away from the parties, bringing it back in close and looking actually at the people involved in the decision. Drawing on feminist legal theory, that might be challenging the distinction between formal and substantive equality, or looking at the way in which privacy plays out in terms of the public spaces and private spaces. It might be drawing on an ethic of care approach to, as opposed to a rights-based approach in resolving a dispute. And obviously also looking at questions of race justice and gender justice. So, in the long term, I'm hoping that by demonstrating how gender and race justice can actually be achieved within our legal system without doing anything particularly radical, we hope this will actually lead to concrete improvements and a greater awareness, I suppose, in the judiciary in the way in which they write their judgments and the sorts of outcomes they reach, and that this might actually lead to improvements for women and for Māori women. The Law Foundation funding was critical to this project. We couldn't have done the project without the Law Foundation's funding. The main reason was the importance of the collaborative exercise. It was getting together in person at the workshops to talk about the judgments, to talk about how to write a judgment, and also to foster the connections. So I would say one of the key outputs, although it's not a tangible output, there's an intangible output from this project, is actually the relationships which have been formed all over the country by 58 different members of the legal profession and legal academia. I think it's particularly important for the Law Foundation to keep funding socio-legal projects or critical legal projects, as well as other sorts of projects, because these are the projects which work outside the box, which look at the law from the outside and try and say, well, look, how can things be different? And these are the sorts of projects which have the potential to really make changes to the operation of the law in New Zealand, and to really challenge and critique it in a way which is essential to an open democratic society.